Today we're going to be covering a full review of the AP U.S. Government exam, including required documents, landmark Supreme Court cases, and the free response questions. So to begin with, we're going to look at the foundational documents. But before we start with those, the link to this course is in the description if you want to go back and look more carefully at some of the things that we're going to cover today. So, starting with the Declaration of Independence, it was a written document of grievances to the king, discussing natural rights that the government should protect, as the American colonists believed that the British government wasn't protecting those natural rights. Next, we have the Articles of Confederation. Of course, this ultimately failed, leading to the Constitution. Probably the most important thing to know with the Articles of Confederation is that it failed because of the Shays' Rebellion, which exposed the many weaknesses of a weak central federal government. They also didn't have the ability to tax as a federal government, and there was no way to regulate interstate commerce. So those are just a few of the reasons for the Article of Confederation's failure. Next, of course, we have the Constitution with its amendments. Now, the most important amendments that you're going to need to know are the Bill of Rights amendments. We'll cover those in the Supreme Court cases next. And then, of course, you also need to know separation of powers, federalism, popular sovereignty, all of those principles of the U.S.'s democracy. Next up into the shorter documents, the Federalist Papers. So we have Federalist number 10 to begin with, and this discussed factions and their dangers, but also how a large republic can control them. So it was advocating for a larger central government, as factions were seen as inevitable. They would happen no matter what, and the best way to control them would be through a large central republic government. Next, of course, we have Brutus, the anti-federalist paper, which discussed its concerns of a large federal government, including that it had the power to bring tyranny back to the U.S., which the colonists had just taken out through the Revolutionary War, eliminating the British government's rule. Then we have Federalist 51. Federalist 51 discussed checks and balances and how they can prevent tyranny. So basically a rebuttal to Brutus 1, saying, hey, we actually can have a large central government. We just need checks and balances on each of the branches. Now, some people may say that these checks weren't strong enough, which is a possible limitation that you could use in your argument essay if Federalist 51 is a part of it, as long as you can find a document to evidence that. Next, we have the letter from Birmingham jail, which encouraged civil disobedience, talked about whether it was morally okay to break laws or not, and advocated for peaceful protest in the civil rights movement, of course, written by Martin Luther King Jr. Next up, Federalist number 70. Federalist 70 discussed why there should be a singular executive within the U.S. government. Now, of course, if you don't already know this, the Federalist Papers as a whole were advocating for the Constitution written by John Jay, James Madison, and Alexander Hamilton. And so this one was discussing the executive branch specifically. They said that there should be a singular executive as it improves accountability, as there's only one person, and also increases public scrutiny on the executive, pushing them away from taking part in tyrannical acts, which is what they need to convince the anti-federalists would not happen in order for them to ratify the Constitution. And the final foundational document is going to be Federalist number 78, which talks about the requirements for a judicial branch, discussing that it had to be independent politically and the justices must serve life tenure. It also was going to be the least powerful branch of the government, as it didn't have power over the sword or the coin, something like that. And it also established that there had to be judicial review, or suggested that there had to be judicial review, which of course would be upheld by the Supreme Court in the first required court case, which we are about to cover. So now we've covered those foundational documents. Let's go into the 15 landmark Supreme Court cases. These are bound to show up on your test either in the FRQ or MCQ, so it's very important that you know these. So right now, I'm going to give you guys some context behind each case and the constitutional principle that the Supreme Court ruled with. So starting with Marbury v. Madison, of course, it established the precedent of judicial review. Now, there's not necessarily a constitutional principle that you need to know for this one. You just need to know that it established judicial review as the Supreme Court declared something unconstitutional for the first time. Next, we have McCulloch v. Maryland, which strengthened the power of the federal government through the necessary and proper clause, as Maryland was trying to tax a federal bank, and the Supreme Court ruled that they could not do this through the necessary and proper clause, as federal orders go above state orders. Next, Schenck versus the United States, which introduced the clear and present danger test for freedoms of speech, ultimately establishing that there was some limit to the First Amendment's free speech clause. So what was happening in this case was that Schenck was spreading anti-war letters trying to get people to defect after they were drafted, and the Supreme Court ruled that the U.S. government actually could arrest him under the Espionage Act for this anti-war speech because there was clear and present danger with the speech. Next, a very famous one, Brown v. the Board of Education. Of course, in this case, Plessy v. Ferguson was overturned through also known as the separate but equal doctrine, as the court ruled that separate but equal is inherently unequal, leading to the integration of public schools. Now, the constitutional principle for this one is the Equal Protection Clause in the 14th Amendment. Next up, we've got Baker v. Carr. Now, there are two landmark Supreme Court cases that have to do with redistricting. This one, however, is the one that's not based on race. A good way to remember that is that Shaw v. Reno has an R, so race. This one instead was just based off of population and allowed federal courts to consider legislative redistricting cases if they thought that they would be gerrymandering through by putting a certain amount of population in certain districts. Of course, we should all know what gerrymandering is. Engel v. Vitale. This case happened after a New York State law was passed that established a prayer in all of their public schools in the morning. While this prayer was not mandatory for students to partake in, it was still seen as a violation of the Establishment Clause of the First Amendment, as the state was endorsing a prayer in schools, which of course breaches that line of establishment of a religion in federal institutions. Next up, we've got Gideon v. Wainwright. So this is one of the first cases that we're going to see that uses selective incorporation, which is a part of the 14th Amendment that allows for the Bill of Rights to be covered not only in the federal government, but also in the states. So in this, the Sixth Amendment right to counsel was extended to states, not just the federal government. Now, the way this works is through the Due Process Clause of the 14th Amendment, which allows for selective incorporation, which allows for the Supreme Court to rule that the Bill of Rights can be applied to state governments as well, not just federal governments. So in this case, there was a man that was not provided with counsel, as a Florida state law did not require him to have one, even if he couldn't afford one. And so, of course, he sued, and the Supreme Court ruled that he did have that right through the Sixth Amendment right to counsel, and ultimately they used selective incorporation to apply the Sixth Amendment to all states. Next up, we've got Tinker v. Des Moines, one of the more famous cases like Brown v. the Board. This one was about free speech in schools, and it protected students' freedom of speech in schools as a whole, basically saying that students do not shed their rights at the schoolhouse gate. Now, what happened was that a few students were protesting the Vietnam War by wearing armbands, and the Supreme Court ruled that in activities like this, where they aren't disrupting class at all, the behavior cannot be prohibited, as they don't lose their right to freedom of speech in school. Next up, we've got New York Times versus the U.S., which established the prior restraint doctrine, limiting the government's ability to censor the press. Of course, this relates to the freedom of the press of the First Amendment. So what happened? The New York Times published the Pentagon Papers, and the Nixon administration attempted to censor them. However, the Supreme Court ruled that they could not do this, as it didn't violate the clear and present danger laws at the time. Next up, we've got Wisconsin v. Yoder. Now, this case regarded an Amish family who wanted to pull their kids out of public school early in order to help them work on their crafts for their religion. And the Supreme Court ruled in favor of the Yoder family, saying that in the free exercise of the First Amendment, free exercise clause of the First Amendment, they were allowed to pull their students out of school early in order to educate them about their religion and improve their craft. Next up, we've got a very, very famous one, Roe v. Wade. Now, at the surface, it established a woman's right to abortion, but the constitutional principle is key for the AP exam. It did this through the Equal Protection Clause of the 14th Amendment. Next up, Shaw v. Reno. This prohibited redistricting based on race, limiting the creation of racial majority districts in legislative redistricting, of course, falling under the Equal Protection Clause of the 14th Amendment once again. Next up, we've got the U.S. v. Lopez. This is our first one in a while that hasn't fallen under the category of an amendment. In fact, this one's a little weird. The constitutional clause is the Commerce Clause, as Congress attempted to enforce certain laws through the Commerce Clause, stretching it too far, and the Supreme Court ruled that they couldn't use something like the Commerce Clause to regulate where people can use guns. Next up, McDonald versus the City of Chicago. This is another one that uses selective incorporation, as the City of Chicago attempted to take Old McDonald's gun, and he sued them, and the Supreme Court ruled that the Second Amendment is covered by the 14th Amendment through the Due Process Clause and selective incorporation, and therefore must apply to states. And finally, Citizens United versus the FEC, the most recent Supreme Court case. In this case, the Supreme Court ruled that corporations can spend unlimited amounts of money on political campaigns as it's protected by their freedom of speech in the First Amendment. Now that we've covered all of the essential documents in court cases, we're going to quickly recap the FRQ categories. Of course, in the argument essay, you must use evidence from required documents and course concepts to make your own thesis and defend it. The SCOTUS comparison requires you to compare a non-required one with a required one, assessing similarities, differences, and impacts. Quantitative analysis requires you to analyze data presented in a chart, table, or graph and draw conclusions based on it. And finally, the concept application requires you to apply concepts from the course to a given scenario. So let's take a look at what these can look like. First up, with the argument essay, your argument should reflect a comprehensive understanding of U.S. government principles. It's very important to include what you learned throughout the year in your essay. Now, you may be required to use certain pieces of evidence, but you can also pull from anything that you've learned. For example, if the prompt concerns the balance of power between the federal government and the states, you can cite Federalist 51 to support your argument for a system of checks and balances. For this one, just make sure that you take a debatable thesis. If you take an AP seminar, you know how to do this, but it should your thesis should include words like should, so that someone can argue against it. Next up, we've got the SCOTUS comparison case. Your goal is to dissect both cases. One of the required ones that you're not given any context about, and then a non-required case that you are given context about. For example, you might be asked to compare Marbury v. Madison with another case involving the balance of power between the branches of government. In this case, you would need to explain how both cases address the separation of powers, but also highlight what makes them distinct, such as the specific powers being contested. Next up, we've got quantitative analysis, probably the easiest one. You're basically just going to look at a graph and see, does it support a particular policy increasing or decreasing, and then make informed inferences based off of that graph, analyzing the patterns and thinking what they might suggest about the priorities of a particular group of people or the U.S. as a whole over time. And finally, the concept application. Now this one has a pretty broad range of possibilities as for what might be thrown at you. However, an example could be that you might be asked to analyze how the principle of federalism impacts a specific debate over state versus national authority. In this case, you would need to explain the different levels of power granted by federalism and then illustrate how these divisions are reflected or contested in the policy debate at hand. So this is really what you need to build your bank of knowledge in your head for, this concept application FRQ. You want to be able to draw all your knowledge, everything that you've learned throughout the year, to answer this question. And finally, just a quick FRQ writing process. This is just a good 6-step process to master these FRQs. So first, you want to identify any key concepts in the question, any buzzwords that might stick out at you that you heard throughout the year. Next, brainstorming evidence is very important because you're going to want to cite specific court cases, concepts, documents, or data points if it's a quantitative analysis one. Next up, formulate a thesis. Now, generally, you'll only need this on the argument essay. However, it could be useful for other ones just to take a stand and know how you want to argue. Next, of course, structure your response. You will be able to type this year, so you should have plenty of time, and I think it is worth organizing your evidence, especially for the argument essay, where you will need a rebuttal in addition to multiple subclaims. Also, it's incredibly important to write with evidence. As I've said multiple times now, this is where you show what you learned all year. It's a lot different than APUSH, where you just memorized a lot of things for the exam and you were guided by documents for the DBQ and such. Here, you're not given that many guidelines. You're free to use any concepts that you learned throughout the year. And finally, review and refine. You have a lot of time on this exam, so be sure to double check all your answers. As I mentioned earlier, this course is linked in the description. Thank you for watching.